Ready for dictation? Start. I have already explained above that the provision of summary dismissal contained in section 421 is an exception to the general principles of criminal law and even an important principle which governs the mode in which justice is administered in our courts, which no man should be condemned unheard, cannot be extended to jail appeals. Stop. The right of appeal is the creation of statute and the provisions of the statute governing the procedure in exercising that right have necessarily to be observed. Stop. In a criminal matter, then the question is not between party and the principles of civil law relating to setting aside of an ex parte decree cannot be imported into the domain of Indian Criminal Procedure Code. Stop. It is then contended that in this view, Section 421 might render the provisions of Section 417 nugatory. Stop. I do not think so. Stop. The right of appeal under Section 417 remains untouched. It affects only the period of 6 months given by Article 157 C of the Limitation Act for filing government appeals and demands from the executive government extra care and alertness in preferring appeals against acquittal before a summary appeal against the conviction is dismissed. Stop. Para. I am not impressed by the argumentum and inconvenient that this may lead to serious consequences in important cases. Stop. As observed by the Privy Council at page 249 of Palka versus Emperor 18 Patna 234 AIR 1939 Patna Court 47. If the words of the statute are clear, it is inadmissible to consider the advantages or disadvantages of applying the plain meaning, whether in the interest of the prosecution or the accused. Stop. If the section leads to inconvenience, the remedy lies with the legislature. Stop. For reasons stated above, I hold that once an appeal preferred by the accused against his conviction of a minor offense is dismissed either summarily or after hearing arguments, the High Court cannot alter or review the judgment, and the government appeal against an order of acquitting the accused of a major offense will then become futile by reason of the previous judgment having become final and effective. Stop. I am therefore of opinion that this appeal against the order of the sessions judge acquitting the respondents of an offense under section 302 is dismissed. The judgment of a division bench of this court of 5th December 1949 in criminal appeal number 37 of 1949 having become final and effective. Stop. The appeal against the order of the sessions judge acquitting the respondents of offences under section 392 and section 394 is competent. Taking away of cattle by the accused from the jungle where they were grazing was a prelude to the quarrel which culminated in the death of the deceased. Stop. Though connected as having supplied a motive, the incident is separate and the offense is separate, and if the government advocate thinks as mentioned by him in para 2 of his petition of appeal that on the facts held proved the accused can be convicted at least under section 379, he can press this point if despite the dismissal of appeal against acquittal under section 302 he desires to do so. Stop. Para. Call Chief Justice by an order dated 27th July 1950 passed by a division bench of which I and Mr. Justice Mehta were members. Appeal number 100 of 1949 preferred by the government advocate under section 417 Criminal Procedure Code against the order dated 22nd June 1949 passed by the Sessions Judge of Dhar acquitting the respondents of charges under section 302, 394 and 397 Indian Penal Code bracket 4 short IPC was referred to a full bench. Stop.